rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
So before you have a seat, would you please join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Go ahead and be seated. Good morning. Good seeing you. All right, so there's three cases on the court's docket today. 2018 CR 158, State of Ohio versus Rita Newcomb. 2018 CR 156, State of Ohio versus Angela Wagner. 2018 CR 154, State of Ohio versus Edward Jake Wagner. The cases are set for sentencing today. Mr. O'Brien, I'm sorry, he's not here. Ms. Knepp is here on behalf of, there he is. Mr. O'Brien, how are you?
Yes, Your Honor, I'm not appointed on that case. It's scheduled for sentencing,
okay.
So I will not participate.
You're welcome to sit wherever you like. Appreciate your experience. Ms. Knepp is here on behalf of the state. I'll introduce the defense lawyers as the cases are called forward. I asked everybody to say the Pledge of Allegiance this morning as an acknowledgement that this is a government function. Sentencing in criminal cases is exactly that. There's a lot of different perspectives in the courtroom. There's a lot of different interests here. But the one common bond that we have in this function is that it's a government activity. So if you can understand my responsibility is to come at it from that perspective, you're all entitled to have your own viewpoint. But that was the start of it. Sentencings in most cases have a certain amount of emotion. The more egregious the case, the more difficult the facts, often the higher the emotions. In high-profile cases, there's expected public discussion. It's not unusual for people to later on go express their First Amendment opportunities and rights to communicate with each other. Often that means, did the judge get it right? Did he listen to the defendant's side or the victim's side or the state's side or whatever side they advocate for? And that's all appropriate for people to be able to have their perspective as a part of our First Amendment privilege. However, the right to public discourse really doesn't exist in this room outside the rules. And the rules are that decorum matters. So everybody's been well behaved, and I expect that to continue all the way through. As I explain the process to you, I'll expect you to follow the process. It's an open courtroom. The Ohio Open Courts Amendment to the Constitution allows through the internet or whatever access. That's all appropriate, I get that. But the right to public discourse has its limits, so the privilege of being here is only as good as you are. If somebody wants to express their First Amendment rights during the course of the proceeding, I'll shut that down really quickly, because in this setting with emotions on all sides of the case, there won't be any spirited debate. That can all happen out on the street, but it's not going to happen in the room. With regard to some preliminary matters, I want to call attention to the fact that the court staff has done a fine job pointing me in the right direction, getting me to the right places, helping with scheduling. So I guess I want to acknowledge the Pike County Common Pleas Court staff, and then carry that a step further is to acknowledge the Pike County Sheriff's Department and the STAR transport team with regards to logistics and public safety. So to the extent that the sheriff provides a lot of resources, the court wants to acknowledge that also. The process today will be as follows. There's some legal matters to take care of with regard to Angela's case and Jake's case. Best way to introduce them that way. So I'll take care of those preliminary matters after the sentencing involving Rita Newcomb, because that's a relatively straightforward case. But with regard to the legal matters, what I'll do then is this. First, have the state make a recommendation on all three cases, have the victim's statement on all three cases, sentence Ms. Newcomb after hearing from her lawyer and her, Then I'll switch to Angela Wagner's case, work on merger, then I'll work on Jake Wagner's case with regard to merger and sentencing. So we're going to do one state recommendation, we're going to do one victim statement that applies to all of them, and then we're going to individually sentence 3 people. There's a lawyer here on behalf of the victims, Ms. Gall or Golly?
Yes, Your Honor.
Thank you.
Gall on behalf of the victims.
Gall, G-A-L-L-E, but Gall. Thank you for being here. The only unresolved issue is whether or not the victim representative, who you identified as TR, would like that person's identity or their statement to be televised. They have the right to confidentiality, so I just need to know for the media how you want to do that.
Your Honor, there are actually 4 victims that would like to address the court, and for the Constitution and the revised code, they do have the right to be heard at any public proceeding involving sentencing, especially, and I can get citations for that if you'd like, but TR is actually not going to speak. It is going to be for others. I believe Angie Canepa is reading 2 of those statements on behalf of the victims, and then there's a mother that would like to speak, and a niece that would like to speak.
So let's have an understanding. I just wanted to know first whether they wanted to be seen or not. So can you answer that for me?
They have no objection to being recorded.
Okay, thank you. Thank you. Now, the second question would be why at the 12th hour you tell me that you have other victims and you entered appearances for people you haven't entered appearances on. I'm going to give you what you want. To a point. To a point. Because the obligation to come in and represent people doesn't mean to come in and change the script. So there's 10 minutes allocated to whatever 4 people are going to speak. I just need to have an identity for the record. If you want to use initials and give the court reporter their names, that'd be fine. But like you entering an appearance on behalf of somebody that doesn't want to speak really doesn't work for me. So don't answer that. Just understand that I'll give your 4 people 10 minutes, and I want their identity, and you want to give me initials, that's fine. Just write down their name so I have it for the record. Understand? Do you understand? Do you understand?
I need to make a clear record for purposes.
So you can make the record after we're done. Now, do you understand what I just said?
Yes, and I'm
Thank you. Okay, then sit down. Thank you. So, with regard to Ms. Newcomb's case, it's Mr. Gerlach, right?
Yes, that's correct.
Nice to meet you. So, appreciate your representation, Mr. Gerlach. Any questions about the process? This recommendation from the state on all 3 cases, then the victim, then your statement, your defendant's statement, and then I'll sentence. Understand all that?
That's correct.
Does that work for you?
Yes, it works.
Okay, good enough. So, Ms. Konepka, go ahead.
I just want to clarify, Your Honor, you want me to make a recommendation for Ms. Newcomb?
All 3.
Okay. I would like to first place on the record, Your Honor, I did not file a written sentencing memorandum as to Ms. Newcomb. However, I am making the same objection to the timing of the sentencing that I made in both Angela and Jacob Wagner's case, specifically, Your Honor, as this court knows, based on Gilbert Colby. The agreement at the time that these agreements were reached between the parties, there was also an agreement that the sentencing would be delayed until after the dispositions or resolutions of all of the remaining co-defendants in the case. At Ms. Newcomb's time in 2019.
Are you going to make a recommendation on sentencing?
I am, Your Honor, but
I got your objection. It's been in the record 5 times. I don't need to hear it again. It's overruled, so please make your recommendation.
I understand the court is going to overrule me, but I need to make a record.
So, Mr. O'Brien, be ready to stand in, because there's no public debate today. The argument I'm hearing from your co-counsel has been beaten dead. It's been beaten dead. I asked her to make a sentencing recommendation. I asked her previously not to talk over me. The next thing that happens is she'll move to the back of the courtroom, and after that she'll be escorted out of the building, in which case you need to be ready to step in, because I'm not interested in old hash. She objected so many times, I have it in my sleep. I don't need it again. It's in the record. So I'm going to ask her again to make a sentencing recommendation on all 3 cases. If that doesn't work, then I'll take some disciplinary action. It's really easy to follow the rules until you don't have respect for the rules. So there's no debate today. We're just going to do this. I'd like you to be ready to step in case it doesn't work for her. Understand?
Yes, Your Honor, only thing I would say for the record is that I'm not privy to the previous plea agreements on Jay and Angela and Ms. Newcomb, so I need some time to review those before I would if required.
I understand. Thank you. They're all in writing. Thanks.
And at least I think that Ms. Canepa should be ready to proceed with
I hope so.
recommendations on
Yeah,
all 3 cases.
that's what I asked for. Now, recommendations.
Certainly, Your Honor. Regarding Ms. Newcomb, Your Honor, I'm deferring to the court on that. We did not have an agreed sentence in that case, and she has been very cooperative, and she did testify in George's case, and the case has been obviously pending for 5 years now, slightly more than 5 years now, slightly under 5 years, I guess, since her plea. And so I would defer to the court as to what Ms. Newcomb's sentence should be. As to Ms. Wagner, Angela Wagner, I'll proffer my objections after the court hearing so that I don't disturb the court any further on that. But I would simply ask the court to go along with the joint recommendation of 30 years. I know Mr. Craig has filed a sentencing memorandum in which he indicated that per a recent ruling, I believe December 9th, the court can only run 2 of the gun specifications consecutively. There are 6-year gun specs on multiple offenses, so of course the state would request that the court impose the 6-year gun specifications as the 2 counts. And then I don't really care how else the court gets to the 30 jointly recommended sentence. As to, I will note for the record that Ms. Wagner did appear and testify in her son's case, George Wagner's, in 2022, and the state believed, or believes still, that she testified truthfully in that case, so I would put that on the record as well. Regarding Edward Jacob Wagner, similarly, Your Honor, we would respectfully request, and I obviously did forward sentencing memorandums, that basically says the same things, but that we would request that the court go along with the joint recommendation in this case, which is specifically, and I provided a chart to the court, just because I know at some point the court has to create a sentencing entry, and outlaying what the maximum sentence is in each of those. That was the joint recommendation, is that he receive maximum consecutive sentences. I think at the time that Judge Deering took the plea, obviously he also indicated he would be going along with the joint recommendations for what that's worth. And I believe during the colloquy with Mr. Wagner, he did ask him if he understood that he would probably, that he would not live outside of prison. And Mr. Wagner indicated that he understood that. The sentence that was jointly recommended is the same sentence that his brother, George Wagner, got, and then they are very similarly situated in that both of them went up on the hill that night and were responsible for the deaths of these 8 individuals, I should say, and on Fort Road. So again, Your Honor, I would respectfully request that the court impose the jointly recommended sentences. These were very carefully negotiated and constructed agreements. Both parties were fully represented, and these were the recommendations of all parties involved.
Thank you very much. So, Ms. Gall, how do you want to introduce your first victim? Initials?
Yes, Your Honor.
Okay, so who's first?
Andrea Shoemaker, she does not.
Oh, okay. Thank you, Ms.
She's the
Shoemaker.
mother of
Go ahead. Thank you, Ms. Shoemaker. Just stand, if you would, right there is fine. The court reporter is the most important person here. She needs to hear what happened, so go ahead. Thank you.
Andrea Shoemaker, I'm Hannah Hazel Gilby's mom. You three helped plan, carry out, and murder my grandson, Rhoden, who was 6 months old, laying in the bed between his mom and dad. Frankie, Rhoden, Hannah Hazel Gilby, let alone your granddaughter's mother. How greedy of a grandmother are you? How greedy. You killed your granddaughter's mother. You're evil. You're evil. You are the spawn of Satan. And the Satan is Billy Wagner. You are the evilest mother to help plan, carry out, and take the lives of 3 other mothers. My daughter was only 20, and you want 30 years of your life behind bars. 30? She was 20! 20! She never even got to buy alcohol. She got 6 months of her life with her kid. 6 months. And Hannah Mae Rhoden, the love of your life, Jake Wagner. The love of your life. Your daughter's mother. She got 4 days. Kylie Rhoden got 4 days. Do you know what kind of questions I have to answer? First, it was bad people came in. Next, they seen your faces on the news. So guess what? I had to explain more. Because they're not little kids no more. They're not 6 months old. They're not 4 days old. Ruger's soon to be 10. 10 years he's been without a daddy to teach him how to fish, to teach him how to hunt, to do all the man things. He has to depend on uncles, cousins. Because of you, Jake. Greedy Jake Wagner. You. I want you to suffer. This is what I want. And I've told all of BCI. I want your mother to live and you boys to die as well as your dad. I want you to die so your mom feels the heartache of what it's like to bury a child. It's a heartache that never goes away. I hate you. You ruined my life. You ruined innocent children's lives. I hope you die. I pray every day you die. I pray your grandchildren and your children never want anything to do with you. And I hope they never do. I hope your daughter hates you with a passion and as much heart as I hate you, Jake Wagner. You shook my hand and acted as if you was my fucking friend. After you shot my daughter 5 times in the head. 5 times, man, while her son lay between them. And Hannah Mae, she's holding her little girl. And you shot her. How cold and evil. You are the spawn of Satan. I'll say it again. Spawns of Satan, you and your brother. And you, evilness, created them. And Miss Rita, I feel so sorry for you because I know you're ashamed to have such a daughter and grandsons that evil. Because you was the first to feel the guilt and say you were sorry, and it was your Christian duty to tell the truth. So I have not very many words for you. My heart breaks for you to have such an evil, control, and spawns of Satan.
Thank you, Mr. Maker. Who's next?
Actually, Your Honor, Ms. Canepa has 2 written statements that they requested she read, and then I do have one more live statement
Thank
from
you.
Lisa Weisel.
Okay. Who's the first statement from Ms. Canepa?
It's Bobby Jolene, Your Honor, the individual who first discovered the victims in this case. This whole experience has been absolutely devastating. I just want to make it crystal clear that I hate you and I will never forgive you for what you've done. You're a coward. I hope the rest of your life is absolutely miserable. You don't deserve to be alive. It makes me sick that you're allowed to breathe the same air that I breathe. You have destroyed my life and the lives of so many others. There's a special place in hell for people like you. You want to act like you're a Christian and God fitting me in, and that cannot be further from the truth, for God hates people like you. You are the devil. All of this is because of you and your mother on a power trip, fueled by the need to control that poor child's life. And now your daughter has lost everyone. She no longer has her mother. Tina Rhoden, you've taken everything from that child that you were supposed to protect and provide for. Your daughter will always remember you as a monster and a coward, nothing more, nothing less. All I really want to know is why. Why did they all have to die? Why did you think you had the right to take 8 lives? I'll never understand it all. It feels like a bad dream that I'll never wake from. Congratulations to you, Jake. You have made your daughter an orphan and put yourself in prison for the rest of your miserable existence.
That's the end of the first one.
That's the end of the first one, Your Honor. The next
And
one. I'm sorry.
as you well know, court reports ability to keep up with words, not as quick as we can talk.
I know you were limiting us on time, so.
Go ahead.
The next one is from Ruth Rhoden, who is the stepmother of Gary Rhoden. I would like you to know that you killed more than 8 people. Kenny, Gary's father, literally grieved himself to death over the murder of his son and the others in the family. Gary was a good-hearted person, and he would give you the shirt off his back. He never missed his father's birthday or mine. He made it to every holiday. I truly feel that you did much more, so much more, these crimes than you're doing too. I ask for justice for Gary and the others in this family. Sorry.
Thank you very much. Last. What's your name, please?
I am Lisa Weigel. I am the niece of Chris and Kenneth and Dana.
Thank you.
I am going to be speaking on behalf of the Rhoden family today. My family feels very strongly that some people have lost sight over what has brought us to this courthouse over and over again, year after year. Let me quickly remind you of the magnitude, the severity of this tragedy. This monstrous crime is the largest mass murder in Ohio. 8 people were brutally murdered. 2 young mothers and 1 young father. And I'm going to drop the babies, please, I do. It is nearing the 9-year anniversary, and I assure you, no one wants justice more than our family. However, we do not agree with making hasty decisions to get it over with. We want all responsible parties to be shown no mercy, just like our family was shown no mercy. We can only pray that actions that take place in this courtroom today will not dismantle the justice that still has not been served. The Wagner family are master manipulators. It will tell of what the lies to fit their narrative. They are a true danger to society, and this crime is nothing to be taken lightly or play jeopardy with. And on behalf of me, and what I have to say, Jake, we are no longer a family. You've said that over and over. We will always be family. No, we will not. I will no longer ever think of you after today. When those doors close behind you, you will be an afterthought to the rest of our family.
Thank you, Ms. White. Okay, so Mr. Gerlach, you're first and your client, so go ahead.
You can sit or stand wherever you're comfortable. Okay. I'm attorney Franklin T. Gerlach, and I represent Rita Newcomb in this case. She has cooperated with the court and the prosecutor, and as I understand it, there's still another trial, and she is willing to do what she has done before. Now, looking at her, she's already been in the jail approximately 8 days I'm not sure on the records. And for a year, she wore the ankle bracelet, and her movements and contacts were restricted. And she just recently had open heart surgery on which installed a new valve in her heart, and she's doing fairly well from that. She is on limited income. She gets $981 from Social Security, and we would offer to the court that perhaps the most appropriate thing would be a sentence that her service already be complete, and that there be no financial fine, because she really doesn't have the money to do that.
Do you want to say something? Thank you, Mr. Gerlach. Ms. Newcomb. Thank you very much.
And I'm sorry.
Stand up.
I'm just sorry for all the trouble. I'm sorry.
Is that all? Okay. Thank you. Go ahead, have a seat.
And that would complete our presentation.
Thank you. So this offense is called obstructing official business. It's a second-degree misdemeanor. Maximum penalty is 90 days in jail and $750 fine. So that's the way the plea agreement was presented to the court. Those are the maximums defined by law. The other charges, whatever they were dismissed, so they're of no concern. With regard to the outcome, the probation department's been monitoring her behavior since 2018 and gives no negative reports. So that's a crystal ball in one respect, because the past often predicts the future, but it doesn't have to. So their recommendation informally, without a full report, is that she continue on supervision. So I'll set a 5-year term of adult probation supervision, 180 days jail, 173 suspended, 7 days credit. So no additional time now. You can, however, Ms. Newcomb, earn the additional 173 days if somehow you don't take this seriously and don't report or violate laws. So there's a long list of standard terms and conditions of supervision that the court's going to, wait, let's go with I'm talking first and you don't. This is how the problems develop, all right? So you've been on supervision, but it doesn't count, the past doesn't count toward the future, that's pre-trial. The past does help me indicate I don't expect to see you again because the probation department seems to think you're not a problem. But I'm going to put you on supervision for 5 years and tell you that there's 173 days suspended in case you can't comply moving forward. I'm going to order the $750 fine plus the court costs, and then your ability to pay over time will affect whether it's actually collected. Because if I don't impose it today, I can't impose it later. Understand? The terms and conditions of probation will primarily involve your compliance with the law, reporting requirements, and then any education or training programs they think are necessary for you to be a good citizen, which in your case may not be a lot, but that's generally the purposes of supervision, is to help people become law-abiding people if they aren't already. So 173 days at risk, there's a $750 fine, plus the court costs that have to be paid, subject to ability to pay. Understand?
Can I ask you a question?
Sure.
Do I have to go to jail?
You want to answer that or should I?
I prefer you say, but I think no.
No, unless you act out.
Oh, okay.
173 days suspended.
Okay.
But it does demonstrate a good point. What I think I'm saying isn't what people are always hearing.
But there will be a fine. And
Yeah.
if I'm bad, I'll go to jail. But if I can stay good, I don't have to. But I do pay the fine.
Yeah, subject to your ability to pay.
Okay.
Like, the point's not to put you in poverty. The point is to modify your behavior. If you have $30 left at the end of the month, then that should go toward the fine or the costs. At the end of the 5 years, if you can't pay it, you don't get incarcerated for being poor. It's forgiven at that point in time, but it is meant to be a punishment. Does that help you?
Yeah, I think I understand now.
Okay. Keep doing what you have been doing with regard to probation compliance.
But I still call in if I have to leave the state or something.
Or show up, whatever they say, you step and fetch it.
Okay.
Corrections or clarifications, Mr. Gerlach?
Clarification, in the entry, it says 90 days is the maximum.
I did say that wrong. It's 90 is the maximum. Yeah,
And you said 170.
I did. It's 83, not 90 is the maximum. I said 180.
Yeah.
I bumped it up a letter, so 83. Thank you very much. My sentencing entry is actually back there on the desk right now, which doesn't help me here. Thank you for that.
Thank you, Your Honor.
So 97 credit, 83 suspended, $750 fine plus costs.
Yes, Your Honor.
5 years probation. Thank you for that correction. My apologies.
No problem.
Thank you. Ms. Canepa? Okay, you can check out right now if you would, Ms. Newcomb. That doesn't mean you have to leave the courtroom, just means I need that chair.
Oh, okay.
Thank you, Mr. Gerlach.
Thank you very much, Your Honor.
We'll switch to Angela's case next. And we'll need another chair. You can help us. I think we will. I don't have it. You have co-counsel with you today, Mr. Burns? Are you by yourself?
Mark Hunt is not here today.
Oh, my apologies. Okay. So this is State of Ohio versus Angela Wagner, case 156. Mr. Crapence is here on behalf of the defendant. Mr. Hunt's not appearing, so we don't need the extra chair. And you had an opportunity to hear the victim's statement and the state's recommendation, right, Mr. Ferentz? Crapence, I'm sorry.
You're fine. I have, Your Honor. Thank you.
Okay. And you heard it also, right, Mrs. Wagner? You heard everything that was said before, right? Okay. I want to circle back on one thing, Mr. Crapence. Was there any part of the plea hearing that you thought was in error or deficient or you wanted repeated?
No, at this time, nothing comes to mind.
Okay.
But
Yeah, I wasn't here,
no,
but if there was an error, we can still fix it.
appreciate that.
Did you note anything that should be emphasized, Ms. Canepa? Any problems with the plea? Okay, thanks. So it's the defendant's opportunity to make a statement, so Mr. Crapence gets to go first, then Ms. Wagner, you get a chance, so go right ahead.
Your Honor, thank you. First, with respect to maybe some merger issues, I suggested in my sentencing memorandum that there are two sets of 2 counts each that we believe should be merged for purposes of sentencing. That was counts 16 and 18, as I recall, and I believe 20 and 21. If I can read my writing again. And I won't repeat the arguments therein. I pointed the bill of particulars with the specificity of what actually was charged, and it seems to me that they are similar imports as if they should be merged. I don't know that. I have not read a response to that, so I don't know the state's position on that. With regard to the sentence or the plea agreement and maybe the agreement on sentencing, Ms. Wagner is very cognizant of the fact that this court's not bound by anything that happened before this court took over this case. In fact, Judge Shearing also was not mandated to follow a jointly recommended sentence. Now, he did review it. He did say he would agree with it, but that in no way binds you. And my client is very aware that this court has the authority and the responsibility for deciding independently what the appropriate sentence is. So we do not walk in this morning expecting that this court we'll just rubber stamp the things that have happened before. But for the following reasons, I think that the court should accept the jointly recommended resolution in this case. As this court knows, these are horrible events. I appreciate the families being here and making the statements that they did. They have shown a lot of patience and I think and courage and repeatedly showing up for every hearing. I do appreciate that, and I know that their words do not fall on deaf ears. Your Honor, my client was involved with these actions. As far as her specific actions, she did not enter into any of these dwellings. She did not bring a gun personally. She did not pull a trigger. She did not directly cause the death of these folks. That said, she was aware of it. She took her own steps to try to assist in that plan. And that is something that she has taken responsibility for. In addition to taking responsibility, she has come into this court and she's testified against her son. And that was a task that was not very easy for her. It was important for her to do so, but it was also very important for the state. The state knew that the remaining cases after Jake had entered his plea were still not 100%, not an absolute win, because one person saying something sometimes without corroboration isn't enough to sway a jury to prove beyond a reasonable doubt. It's very important for them to have Ms. Wagner come in and testify and corroborate the testimony, the evidence, and the facts that Jake had testified to. Toward that end, after Jake had proffered, we never let Angela review the statement, the proffer, because we wanted to keep a clean wall between the two of them, such that she would not parry back what somebody else had said. And I think it proved her value to the state as a witness. And it's because of those efforts that the state entered into this agreement, which I know the state probably didn't like, but felt it was necessary, and I think that they probably made the right call. Ms. Wagner has lived up to her end. She will continue to live up to her end of the deal, which again doesn't bind this court. I do want the court to know that she has provided me this morning with a list and some certifications of completion of some programs that she's taken while she's been incarcerated for a very lengthy time in Delaware County. And I count offhand, I'm not going to read them all, but I count probably 40 to 50 different programs that she has completed. She has found something of a niche, and she's been in one place so long. She's been, entrusted to act as a trustee, but also has taken it upon herself to mentor young women who come in to the jail, and then they come out, and they come back in, and she's told me many stories about the revolving door of women that she's met and been able to help. I believe that she, for the next more than almost 25 years of her life, will have a purpose. I know that she is the type of person who will listen, who will help to counsel, who will try to direct younger women into the right direction, a path that she hopes that they will take. She has done as much as she can possibly do to improve herself, her situation, and to give back. She has written a statement at the appropriate time. I would ask the court to allow her to read that as well. All that to say, Your Honor, I believe that the jointly recommended sentence is appropriate. I know that in the plea agreement, we had agreed to a specific sentence for each of these counts. However, as my addendum to the sentencing memorandum indicated, I don't think that we can follow that because of how the Supreme Court has interpreted the law with regard to firearms investigations. I did include, it was yesterday at some point, a suggestion of how to arrive at the same, if the court is inclined to, and do so in compliance with, I believe, would be the appropriate legal framework. Thank you.
Thank you. Ms. Canepa, do you agree that 18 merges into 16 and 19 merges into 20?
into 20?
Unauthorized use of property, that's the way it was suggested by Mr. Craypence.
Yes. I would agree that there could be an argument as to 16 and 18, but not the 19 and 20, Your Honor.
Want to argue that further, Mr. Craypence?
No, so nothing past the motion. Thank you.
Okay, thanks. So I looked at the bill of particulars and read the indictment. I don't have all the discovery. When I read through the trial transcript, I can agree that 19 merges into 20 and 16 merges into 18 merges into 16. So I presume you would have the court sentence on the higher level felonies, Ms. Canepa?
Yes, please.
So
Your Honor.
16 is a felony 3 and 20 is a felony 4, so there'll be no sentences imposed on 18 and 19. They merge into 16 and 20. That being said, it's your turn, Ms. Wagner, for your statement.
Thank you, you're here. I have to tell me if I'm close. There I go?
Yeah.
Oh, thank you.
I've spent my whole life trying to be the opposite of everyone that I knew. Not too fluffy, not too wordless, not too strict, not too controlling, not divorced, not too ungrateful. The perfect daughter, wife, mother, grandmother, perfect person. Always striving for perfection, thinking that that was what was wanted of me. All of this had been stuffed down so far that I didn't even know who that woman was. I didn't realize I was so weak and flawed and broken that it would lead me to make rash emotional decisions. That when such a tragic event would happen within my family, I just froze. I couldn't think. I'm not saying this for justification, Your Honor. This is why it shames me to say at that point in time, I didn't consider the consequences of those actions would cause, or the depth of pain that they would bring upon the Rhodens or others. I know their pain must be unbearable, because separated from my family, the ones I love most in the world, brings me unbearable, suffocating pain too. And for this, I am so truly sorry. I can't undo what's happened. But the regret and the remorse that I feel is my daily reminder of who I once was and who I do not ever want to be again. Thankfully today, I'm not that woman. I've committed myself to change, to growth, spiritually, mentally, and emotionally, to letting God be my guidance. Each day I work on being a better me, rewiring my brokenness, living for a purpose so I can be filled with wisdom, knowing to slow down, to listen, and to ponder so I don't get carried away with any emotional decisions again. I'm not looking for perfection anymore. Now my desires and goals are for continuance of growth, for sharing the compassion and unconditional love to others that God shows me daily, and to remain this better me. God has opened my heart and my eyes. He has showed me what reality looks like. I've seen it in all the beautiful, unique women that I have met and been sharing housing units with. This world needs no more pain, so I give back any way I can, whether it is to show love, compassion, encouragement, a listening ear, a smile amidst their darkness, or just maybe by hearing my story, they will be enlightened of what real consequences made by emotional decisions looks like. My hopes and dreams are that I can make each day count for something good, to always move forward, not backward. Because all I am today, I have to give that glory to God. It's His love, His mercy, and His grace that has changed me. Thank you.
Go ahead and have a seat. So, Mr. Craypence, let me start with you. Thank you. I don't think the public understands the stress on the lawyers for both sides of the case. I also don't think the public appreciates the fact that without defense lawyers, there wouldn't be a prosecution. Because in our adversarial system, as much love as the state might get, the defense lawyers seem to get the opposite. Yet you step into those shoes, and in this case, I've seen very capable lawyers working very difficult facts, often without any appreciation. So to the extent that you and Mr. Hunt did a fine job, you ought to at least be publicly acknowledged. So thank you very much for a long career.
Thank you, Your Honor.
The first part of the hearing, when the victims were speaking, was what I expected. A built-up, raw emotion of rancor and ill will, and all very understandable and unfortunate. If anything cathartic can come out of today, it might be of the fact that there's some closure, or maybe not forgiveness, not forgetting, but the fact that the process will have worked and people can move on. Whether you choose to accept that or not is yours, as any free person can, but maybe closure helps. There was a reference to this being the worst massacre in the state of Ohio. Well, let's go with something else. To call this the Pike County Massacre, frankly, is condescending to the rest of the good people of Pike County. It's tragic, it's heinous, it's unexcusable, but it's not an indictment of the entire county. That's social media typecasting. The worst massacre in Ohio might very well be 1792 at Grenada-Hutton, when 96 Christian pacifists were killed by the Pennsylvania militia because they were Christian pacifists. But each generation has its own people who can prove the depths of depravity of human nature. And that's what this case did. It showed the boundless depravity of people who have no respect for others and their only self-interest in mind. And that's transgenerational. Since the dawn of man, this sort of depravity happens. So the raw emotion you communicated was expected is unfortunate, and I hope somehow you're able to get past it. Not forgetting, but getting above it. But good luck, because what I just asked isn't easy, as you well know. With regard to sentencing, however, the court's not bound by nor has any role in using emotion. The government's responsibility is not to use ill will. We don't have people being burned at the stake as in the medieval days. We don't have public shaming. We don't have a remedy that works. We have analytical guidelines that courts are supposed to follow in imposing sentence. It's not meant to be emotionally driven. So I wipe all the emotion and follow the sentencing factors. The first set of factors are whether the case is more serious or less serious. Clearly, it's a more serious offense for all the reasons stated in the statute. Whether recidivism is likely is the second set of factors. Well, there's a long sentence coming. And I'm supposed to predict the future, which I can't do. So recidivism prediction is virtually impossible. It's backward looking. So I'm just going to find that the risk factors for recidivism are balanced equally against the less likely, because I don't know what you're going to be as a person or who you'll be after your long prison sentence, Ms. Wagner. The fact that you completed 40 or 50 programs might bode well for you, and it might not. So I'm not going to try to predict anything with regard to the future. You need to understand that there's a mutually recommended sentence. If I impose the mutually recommended sentence, then any opportunity you might have to appeal the sentence is waived or given up. Generally, when a person enters a plea of guilty, they give up any rights to appeal the verdict of guilt. So presumably you don't have appeal rights as to your plea. If I impose the sentence today as recommended, then there's no appeal rights on that issue. The only thing that might be left, dare I say it, would be ineffective assistance of counsel, and I don't have any opinion on that. So if I impose a mutually recommended sentence, your appeal rights are waived as to the sentence. Do you understand that?
Yes, Your Honor.
And that's what's going to happen. I lined up the numbers differently than the lawyers recommended, but they come up to the mutually recommended 30 years. So for purposes of the record, with regards to count number 9, complicity to aggravated murder, I impose a 9-year prison sentence. On counts 10, 11, 12, and 13, I impose a 9-year prison sentence. That's an aggravated burglary. For unlawful possession of dangerous ordnance, count 14, the maximum 12 months in prison. For counts 15 and 17, tampering with evidence, 3 years in prison. Count 16, tampering with evidence, 3 years in prison. No sentence on forgery, no sentence on unauthorized use because they merge. On unlawful interception of the oral communication, 18 months in prison. And then for the obstructing justice in count 21, 12 months in prison. And then engaging in a pattern of corrupt activity, 9 years in prison. Mr. Craypence is right to remind me of the recent case of Beatty. I saw that come rolling out first week of December. Maybe that was in my entry 2 weeks ago with regard to having to follow the mandates. A lot of people might think judges have unlimited reign, if you will, to impose sentence when in fact we have pages and pages and volumes of rules and case authority on how to impose a sentence. So the Beatty case tells me that there's a mandatory duty with regard to the firearm specifications to impose the maximum 6 years consecutively to each other. So there's a firearm silencer specification that has to be imposed on count 9 and count 22. So there's 6 years plus 6 years is 12. With regard to 9 more years for the aggravated burglary charges, those run concurrently with each other, consecutive to the firearm specification. So we're at 6 plus 6 plus 9. And then finally on the corrupt activity charge, count 22, there's a 9-year sentence, which is consecutive to the 9. So now it's 6 plus 6 plus 9 plus 9. Is my math right, Mr. Craypence? 30 years. The other charges all run concurrently, so that felonies 3 and 4 don't add additional time. It's 30 years in prison as mutually recommended. You're entitled to 2,244 days credit over 6 years. 6 years and 6 weeks. So that comes off your sentence as a matter of law, because past time has to count. With regard to economic sanctions, there's no fine. Your inability to pay makes that impossible, not only in the past but in the future. There's a legal obligation to pay court costs, processing, booking, pay to stay, medical expenses. So all those numbers should be added up and put on your bill. Your ability to pay depends on future economic circumstances, but it's a legal obligation to impose. When you're released, you have to be on supervision with the adult parole authority for at least 2 years up to 5 years. While on post-release control, you have to follow rules, regulations, restrictions on your freedom. If you fail to comply, you can be sent back to prison for up to 50% of the longest term, so that would be 50% of one of the 9s. So the 30 can turn into 34 and a half for additional violations after you're released at the end of 30 years. You have a legal obligation to register as a violent offender. There's a database. So at the time of your release, you have an obligation for at least 10 years to register as a violent offender. Tell the sheriff in the county where you reside, where you live. If you fail to comply, that can be a parole violation, post-release control violation, or a separate felony 5 offense. And the legal duty can be extended if the state establishes just cause to extend it beyond 10 years, which doesn't start running until you're released from prison. Did I overlook anything, Ms. Kneppa? Mr. Craypence?
No, Your Honor. My client has signed an affidavit of agency from the clerk.
Thank you. Yes,
Sure.
I'll hand this back to you. You can have the filing done. Further evidence, Ms. Wagner, of how thorough your lawyer is. See it? To the extent that I wasn't bound by the lawyers, I could have gone higher. I wasn't here when this started. The analysis is pretty true. The state needed you. and in fact, you came through with your part of the agreement. Does that matter? Well, morally, that's up to you. Legally, it's a big deal. In my journal entry, there's 2 cases cited that clearly explain the importance of cooperation, the benefits of mitigation. You help the state make the case. Jake helped the state make its case. That wisdom, wherever it came from, was the difference between a much worse outcome that might very well have been appropriate. I understand you didn't go to the 4 scenes. Nobody seems to talk about the fact that you're the only person who could have stopped the whole thing with 1 phone call. You're standing there with cell phones that people want you to ping to make it look like you're home. All you had to do was call in. Stop the whole thing. The depravity was that you didn't see the moral need to shut it all down. I don't need an explanation, but clearly any decent human being could have done that little bit to save so much. So with the fact that you accepted responsibility and cooperated, I was willing to follow the agreement. You'll see the Anderson case and the Rahab case is cited in the decision. They go back to 2017 cases. The Supreme Court made it really clear twice in the same term the importance in the system of having people accept responsibility and cooperate. So for you, that's the only silver lining. That concludes that case. Ms. Wagner, they're going to walk you out the side door and move you on. Thank you, Mr. Craig. It's my pleasure to meet you.
Thank you, my pleasure.
Have a good day. Go ahead and have a seat. This is case 154, stated by Mr. Jake Wagner. Mr. Bay's here on behalf of the defendant, Ms. Roberts. The new tire is also here. Were you able to hear the state's sentencing recommendations and written statements, Mr. McVeigh?
Yes, Your Honor.
Did you hear them also, Mr. Wagner? Did you hear the Do you have any issues or corrections you wished with regard to the plea proceeding, Mr. McVeigh?
No, Your Honor.
Think of anything on this case, Ms. Canepa?
No, Your Honor.
So what we'll do then is allow the defense attorneys to make their statements. You get a chance to make your statement. Choose to do so, Mr. Wagner. So that's how we'll proceed. Understand? I try to speak loudly enough, Mr. Wagner. I may not be doing that.
Oh, well,
Do you have a hearing? Do you have a hearing problem?
yes.
Okay. I will try to speak louder and slower. But anytime you don't understand, do exactly what you did. Make it known.
Okay.
You can't miss this because of a hearing problem. Understand?
Yes, sir.
So thank you. Go ahead.
Thank you. We will do our best to make sure that he has full hearing and understanding, clarify anything that we may ask some questions about. Your Honor, thank you for this time to speak on behalf of Mr. Wagner with regard to this sentence. I will keep my remarks relatively brief. I say relatively because the nature of this case calls for certain remarks to be made. But nevertheless, we have filed a sentencing memorandum on his behalf. This court is well aware of all of the proceedings with this case, the joint recommendation of sentence, the plea agreement that had been entered into, as well as a defendant's agreement that was entered into, and Mr. Wagner has complied with up to this date and would continue to comply with. Again, my remarks will be brief, not because this is not a serious case. No one could, in their right mind, argue or anyone else that this case is not serious. And he spoke in terms of references to a massacre and that sort of thing. There are very few cases in the state of Ohio that would be of this severity. Certainly none that I have handled, although I have handled some multiple homicides involved. But out of respect for the family, the parties, and all involved here, given that this has been litigated, it's been tried, in one instance at least, over the last 6 years, there's very little that I can say that someone hasn't already heard. What I would indicate to this court is that we did enter into, Mr. Wagner and prior counsel entered into an agreed plea agreement, a joint recommendation of sentence with the state of Ohio in this regard. That agreed joint recommendation of sentence was 8 consecutive sentences of life without parole for each of the aggravated murders involved herein. And it was also indicated that we would stipulate, agreed to waive and stipulate maximum consecutive sentences are both warranted, necessary, and appropriate in this case. I believe that probably would address the questions of merger. We know that Mr. Wagner knows that it's up to the court when it comes to sentencing. What I would indicate to the court is that he is fully aware that in entering the pleas that he did, he would be subject to a maximum possible sentence of 8 times life without parole, an additional 160 years if sentences were imposed to the maximum consecutive, and that 78 of the 160 additional years would be mandatory sentences. Again, the parties stipulated, or that we stipulated, Mr. Wagner stipulated to the necessity that consecutive sentence, maximum consecutive sentences were warranted, necessary, and appropriate in this case in order to effect the agreement of the state of Ohio. Again, Mr. Wagner understood what his maximum sentence could be. He understands and understood then that it would be up to the court as to what sentencing would be, but certainly he entered his pleas knowingly, intelligently, and voluntarily, knowing that he was subject to the maximum sentences as already addressed of 8 times life without parole plus an additional 160 years. He also understands that with the joint recommendation of sentence, and he understood this at the time of entering his plea, that with the joint recommendation of sentence, he would not be able to appeal the sentence of the court if the joint recommendation of sentence wasn't imposed by the court. So I think he sits here before you fully knowing what those possible sentences are. He did at the time of entering the plea and knowingly knows what the maximum would be. I believe I've addressed the issues of merger that the court wanted us to do, or asked the court, or asked us to provide additional information in that regards. Your Honor, I could stand here with myself and my colleagues in the Office of the Ohio Public Defender, having met with, and dealt with, and worked with Jay Wagner over the last 6+ years. There's many things that we could say. And I could reference that my colleagues had told me, or things that I could tell you about the meetings and conversations I've had with Mr. Wagner. But I think, in all fairness and honesty to all parties involved here, that what probably speaks to Jake Wagner more than anything is the extent and the value of his cooperation in this matter. He referenced it in the sentencing of his mother, Angela Wagner, that without his information, perhaps convictions would not have been obtained, pleas would not have been entered, and the state wouldn't be in the position where they are today. So again, I think that speaks to Mr. Jake Wagner as much as anything I can say on his behalf here today. Your Honor, I believe that at least by our calculations, we have 2,244 days of jail time credit. If that calculation is correct, I believe that was from a date of arrest of November 13th of 2018. I believe it's close, if it's not completely accurate, Your Honor. And I support to take notice of that. I think the last thing that I would offer is that Mr. Wagner has signed an affidavit in receipt, if I may quote.
Yeah, please.
Has been notarized by myself, although we have a notary stamp. We can see
Do you have a separate entry?
Okay.
Do you have a separate entry? Just sign them up.
Thank you. We provide one to the board.
Your choice.
I don't have one with me.
I can do a margin note if you're satisfied with that.
I'd be satisfied with that, yes, Your Honor. Thank you.
That's
I'll
not
return.
That's it. There you are. John, back to you.
Thank you, Your Honor.
That's all you have, Mr. McVeigh?
John, I would just conclude by saying that, again, we did make a jointly recommended sentence. Mr. Wagner understands what his duties and responsibilities and promises have been in his plea agreement, in the defense agreement. I believe that Mr. Wagner is a man of his word. Thank you.
Ms. Roberts, care to add anything?
No, thank you, Your Honor.
With regard to merger, Ms. Neka, same argument, same discussion?
Yes, Your Honor.
Okay.
I suppose the court will reach the same conclusion.
Yeah, same conclusion. So I think the merger is the same in this case as what Angela's. Academic as it might be, it's nonetheless essential to get it right. Your turn, Mr. Wagner. Anything you want to say?
Actually, Your Honor, I have a lot I want to say. But it's all right.
Just pull the mic closer if you would. Try to keep your voice projected.
Can you hear me now?
Yes.
No, I have a lot I want to say, but if it's okay with you, instead of looking at you, I would like to look at the victims because they are who I really want to
You're
speak to.
entitled to do that.
You don't do that?
You can.
Oh, I can?
You're entitled to do that.
Oh, I can. Okay.
Yeah, so whatever's comfortable. You can stand if you want, you can face them, you can face me. Just make sure no disrespect happens.
No disrespect, no.
Go ahead.
So, each and every one of you, well, not all of you, obviously, but I've had friendship or relationships with a lot of you, many of you. And I know full well that the weight of my crimes, what I've done to you and your family, there's no amount of apology I can give today, no amount of explanation, no thing I can do to help you with the pain you have, loss, anger, hate. Nothing can save that. But I'm not going to tell you, oh, this, and that. I'm going to tell you about me. Because, yeah, I used to be a manipulator. Ms. Gilly affirmed that, and I truly was. But after I committed this crime, I was still a killer. Ms. Gilly, I'm going to look at you because I feel you have the most hate. And this is for you. So whenever I committed those crimes, it was probably 2 or 3 weeks later, I was weighted down with the guilt I did. And I said the most sincere prayer to that day I ever said, to that day. And I asked God. I didn't like what I did. I didn't like how I was living. I didn't like how the possibility of my daughter or even my nephew would grow up to be. And I asked God, I said, put me and my family back on the straight and narrow path by any means necessary. Any. And I can tell you today, I am not sorry I got caught. I'm sorry for what I've done. But I am glad I got caught. I 100% believe that it was Jesus who made me get caught to answer my prayer so he could become exactly who he's supposed to be to each of us. Lord and Savior. Because, silly, now I don't show much emotion. It's not in me. A quiet hour tonight, you've seen God, I do. I won't show much here. I'm kind of breaking up a little bit, but that's just me. I can tell you from my own experience, hate will not heal your heart. I'm not asking you to forgive me. I don't. But I ask you, if you are a woman of at least some kind of faith, you should really read the Bible, because hate won't do it. Hate will only condemn yourself. But I want you to know, what I want to tell all of you, is how I was, and how I believed, and how I truly thought I was going to die and go to heaven prior to being arrested. And how I learned in my own time, alone with Jesus, just him and his word. I set aside every human teaching I was ever taught, even John 3:16. I read the word for myself. John 3:16 don't save you. The Bible don't save you. Only a relationship with Jesus Christ will save you. And he did not promise one place in his word. I don't know how many of you have ever read the Bible. He's never promised he would save you from hell. He promised that he came here to save you from sin, to unleash you from the captivity of sin. We're all weak. We all fall short of the glory of God. I knew that, and I was one of those people who believed, okay, sure, I'm a sinner, I'll sin every day. It's not like, why should I try? Ask for forgiveness while I eat, go to sleep, and I'll be good. I wasn't good. That's not what Jesus preaches. Jesus says specifically, you come to me with all your burdens, all your sorrows, all of your pain, and you surrender, and he will heal you. You know, some of you might know the verse where it says you must become like a little child, or you by no means enter the kingdom of God. You must repent, or you by no means enter the kingdom of God. Repentance is what I thought prior to actually just sitting down and reading the Bible myself. It's not asking for forgiveness. That comes from repentance. Repentance is to choose to look at what you've done, hate it, and forsake it. To forsake sin. Nobody can say that they are a God-fearing Christian, born again, and think sin is nothing. At least little sins. Lying. Lying is just as much an abomination as any other thing. I've committed murder. I've committed every single sin that the Bible lists. Blasphemy, denying Christ, like Peter did. No, he never actually said it. But I have been in silence, and I heard someone else say it. And it's just as much sin. To me, I'm going to tell you exactly how God changed me. And I know it's taking a little bit extra time, but I feel the judge will allow this. It took me about 2 months after I was arrested. And I read that Bible twice, cover to cover. And I did not like what I found. Not the fact that it doesn't give salvation, but the fact that I realized I did not have it. I realized I did not have repentance, and never did. Yeah, I believe it was superficial. My superficial faith had no power to change, no power to save, no power to have godly works in my life. Not one bit. But I was deceived, and every time I read it prior to that, I kept deceiving myself. Well, John 3:16, I'm good. No. You gotta read John through 14, 13, all the way to 21. He tells Nicodemus about repentance. He doesn't say the words, but he tells it. Men don't want to repent if they don't want to come out of darkness. Because their deeds will be brought into the light and be reproved. That's repentance. You know what we ask Jesus to do? Save us. Change us. Because we're sinners. He does not call us into a life of sin and just save us from hell. No, he calls us into a relationship so that he can transform our life so we will be adequate ambassadors of Christ on earth in his love and his forgiveness. Whenever, seeing Miss Gillies laugh, but when all of you guys can probably have the same feeling that she does. When she said that, no, I wasn't crying on my eyes. My heart was breaking for her, just as it breaks for all of you. Because you may be in the darkness that I was in. The hate is the darkness. And I can tell you, not in spite, but I'm not miserable. I don't live in misery. I've experienced your loss. I've experienced your pain. This is my mom mentioned. Because I believe that God done this to me, so he could help me have the compassion and empathy to feel what you guys have felt. Shoot, he's taken my daughter from me, my nephew, those two more than precious people in my life. And he's done that, I believe, so that I would know how he feels about all of his lost children. And that's what I do. I don't need to tell you about how good I am or this and that or what the things I do, because it's not important. I tell you this only because I care for each of you, each of your pain, each of your loss and your sorrow, because kind of like what they had mentioned before, the judge mentioned, it's not about forgetting. The past is in the past. Strive for the future. But I can tell you this, I don't forget what I've done prior to my born-again moment. And I would describe it to you, but there's really no sense in doing it here. But whenever I was born again, I stopped forgetting. I didn't try to forget. I told my testimony to everybody I come across. I told it to them so that they may know that sin's not okay. Crying is not okay. It does hurt more than just us. It hurts everyone around us. Everyone we've known, we don't even realize we're hurting. And there's a consequence to that. And I'm fully aware of my plea. I'm fully aware of the mercy that I've already received. And I am completely willing and ready to pay my consequence for my crimes here. But I want you to know that I have joy and peace and love in my life every day. It doesn't mean I don't suffer the loneliness or pain every now and then. It comes. And when it comes strongly. But I trust in God, because he gives me comfort every time it does. And what he does for me, he can do for you. And I'm not trying to make myself look big and think big shot on the news and all that stuff. Because I know everybody, not everybody, but many people are going to criticize what I say today. And don't get me wrong. Now you see, I did not write this down. Because for the past 3.5 years, I have been thinking about what to say, how I can help you, not justify myself, fix it, or anything for myself, whatever the right word is, but how I can help you, each and every one of you, even my daughter, wherever she may be, everyone else who I've hurt. I want you to know the love and forgiveness that Christ has for you, so that he can bring good, as he promises, out of this terrible situation to help those who still have the opportunity to help. And I'm going to tell you one example of that.
Mr. Wagner, start wrapping it up, will you?
Less than 3 minutes.
All right.
One thing, and I want to tell you, Sheriff, not all the details. If I came in contact with another inmate, this is after my plea. And he told me, because I told him, I'm confidential, not necessarily how a Catholic priest does it, but what you confess to me, I'm not going to tell no one else. And he told me about he was going through a similar situation I was. How he was planning as soon as he got out, he was going to go kill his baby.
Stop.
Say what?
Wait. Okay. Go ahead. 2 minutes.
Well, I was able to spend time with him a lot. And I was able to share with him what my consequences and the pain I've caused to so many people. And I was able to lead him to making a choice for Jesus and not to commit to doing what he said he was going to do. And you know, there's so many people out there who have gone through so many things that you've gone through, sometimes even worse than what you've gone through. And I've read of so many testimonies how they have brought God glory through the evil that has happened, both on my side, the offender, and even on the offended side, showing his forgiveness. And I tell you, forgiveness is a powerful thing. It's so much the hardest heart you'll ever see. And I do that every day with my testimony, my fellow inmates, my brothers. I love them. I shout out to them. And I don't care how much I get persecuted for being called a snitch, for being called everything under the sun. And it's odd because they don't criticize me for what I did, for the crime. They criticize me for taking the plea. They criticize me for standing up here and doing this, what I did for my brother. All of that.
Mr. Wagner, wrap it up, will you please?
My last sentence. I'm sorry. I just want you to know, Jesus has a cost. Obedience, repentance, and total commitment. And when you do that, as I've done, if you've all done it, I don't know, it will transform your life. I hope you all have been touched by that, and at least somewhat plant a seed that your hearts may be healed, at least somewhat. And I do pray for you all. That's all I got to say.
Have a seat. Thank you, Mr. Wagner.
Nothing further from the defense.
Thank you very much. So, Mr. Wagner, that allocution, that statement, further demonstrates the role the court does not serve.
I know.
Everything you just said is perfectly appropriate. It's been heard many times before, as has the victim. But to the extent that there's a religious overtone, I don't factor in religious values. It's the same standard. The legal prescriptions, the laws of the government that I impose. I heard remorse. I heard your understanding and your explanation for it. But to the extent that you might, or somebody might have taken that as preaching, that's fine, except it has no meaning to me, except for remorse. If it was more than that, Mr. McVeigh helped me understand, but it just demonstrates that the same ill will and rancor that came from the victims, understandably, is now your faith experience on your side, neither of which is the role of the judge, the duty of the law. So it highlights what goes on in courtrooms on a regular basis.
Your Honor, what I might add to that, perhaps by way of further explanation, is that I believe from my conversations and conversations with my colleagues with Mr. Wagner, that the statement that he made there was, he wanted to speak to the victim's family, and rightfully so. But I don't believe it was in any way intended to sway the opinion of this court when it comes to sentencing.
We said the same thing different ways.
We did.
I can't accept that.
We did.
For benefit of the record, a lot of the victims in the gallery walked out along the way as they're allowed to. So they don't have to hear what he chooses to say. It's how it works.
Yes, Your Honor.
In fact, this day is more intense than many, but it's all too familiar on the criminal court documents.
Yes, Your Honor.
With regard to sentencing, Mr. Wagner, the court has the same analysis. Severity factors, well, obviously, clearly, there's more serious factors. There are no less serious factors. With regard to whether you're likely to be a repeat offender or not, I'm not going to have a crystal ball to project where you are after a long prison sentence. So I'll just find that the recidivism factors balance out. It's unpredictable, but I did the analysis and thought about it. With regard to the penalties to impose, count 1, aggravated murder, life in prison. Count 2, aggravated murder, life in prison. Count 3, aggravated murder, life in prison. Count 4, aggravated murder, life in prison. 5, aggravated murder, life in prison. Count 6, aggravated murder, life in prison. Count 7, aggravated murder, life in prison. Count 8, aggravated murder, life in prison. Count 9, conspiracy to commit aggravated murder, maximum 11 years out of Department of Rehabilitation and Correction. Counts 10, 11, 12, 13, aggravated burglary, maximum terms of 11 years in prison. Count 14, possession of a dangerous ordinance, 3 years in prison. Counts 15 and 17, tampering with evidence, 3 years in prison. Counts 16 is tampering with evidence, 3 years in prison. Count 18, merges, so there's no sentence on 18. Count 19, merges, so there's no sentence on 19. Count 20, unlawful interception, 18 months in prison. Count 21, obstructing justice, 12 months in prison. Count 22, engaging in a pattern of corrupt activity, the maximum 11 years in prison. And then count 23, unlawful sexual conduct with a minor, a 4th degree felony because of more than 4 years of age difference. In that case, 18 months in prison, the maximum sentence. With regard to firearm specifications, the court's duty-bound under the recent Beatty case to impose mandatory 6 years on the first firearm spec taken from count 1 and 6 years on the firearm specification found in count 2. You're entitled to 2,244 days of jail time credit up through including today. You're required to register as a violent offender. You also have sex offender registration requirements. The sex offender registration requirements apply upon any release from prison, which would be for a period of 25 years, registering at least every 6 months with the sheriff in the county where you reside. If you change your address, take into employment, then you have to change your registration anytime you change your variable. The violent offender database, as you heard earlier, is a 10-year registration which can be extended. And if you fail to comply with the sex offender registration or the violent offender registration, that can be a violation of any terms of release or a separate felony at the time. The Chief Justice appoints retired assigned judges to work on cases where there's conflicts or problems. And I take that very seriously. It's a privilege after retirement to be granted the opportunity to come back and continue to help my colleagues. That's why I get out of bed every day. There's a need, there's a problem, maybe a skill to apply to resolve the need and the problem. That's how I got here. We talked about this with your dad months ago. I got 2 problems when I walked into this case. I'm going to explain the 2 problems. The first problem was a recommendation on your case that was the same as it was on your brother's, life without parole, which is what he got, right? How did he get there? He went to trial. He had 10 weeks of trial, and he had thousands of dollars and dozens of witnesses and emotional energy and staff energy, people energy, resources energy to get him to his conviction. Yet the recommendation here is the same, giving you no credit for all the cooperation that you gave. As Mr. McKinney said, you don't have corroboration of a cooperative witness, you may not have any case. So I have to resolve the first problem is how is it that I'm supposed to treat you the same when in fact you didn't act the same? That's the first problem. The second problem is how do I resolve the good deal that your mom got? 30 years is a really long time. That's a really good deal for the level of the conduct, especially since she could have stopped the whole thing dead in its tracks before it ever happened. And I don't let her off the hook because she didn't go to the scene. I put her equally responsible because the eyes of the law put her equally responsible. So my second problem is how do I resolve what looks to me like some sort of gender violence? And here's how I resolve it. I give you the opportunity of parole after 20 years on your prison sentence. So you do 6 on the gun spec, you do 6 on the gun spec, you do life on all the other counts, everything concurrent, with the opportunity of parole at 20 years. So 32 years out, you get your chance because you cooperated, because you did something to acknowledge the responsibility for the crime. That's not a deal, but that's as close as I can come to solving the problem that's handed to me by these ancient plea agreements. If everybody wants the last judge's sentencing deal, they should have sentenced him under the last judge. Everybody knew Judge Deering was gone right after the last trial, but nobody rushed it in to get it. And when I show up, I solve the problems the way I'm supposed to. So you get your chance to talk to the parole board 32 years from now. And then they do their job, whatever it might be. So I'm not going to sign off on a deal where you get the same for cooperating as your brother does for going to trial. There's the explanation. Court costs, processing, booking, pay to state medical expenses, have to pay as a legal obligation. There's no victim restitution because they have civil remedies available. So you can go ahead and be excused. We're going to register you under both those registries, and we're going to take a break. So we're going to go off the record. Thank you to the lawyers.
Just happened. He just recessed. The judge at the last minute said, because Jake cooperated his brother. So he said, 2 years with chance for he admitted to killing 5
Check on Mr. Fish.
Yeah, tell him I don't put it on channel 2 because I was told to get the mics.
Yeah.
It was very ugly. I did when they read. They said they couldn't hear her. They can hear her if they brought it up because she was coming through. So just tell him, because I'm feeding through my TV, I can't mix the channels, supposedly. I did at the anchor.
He hasn't said anything about the audio.
Okay, well, the other guy said, I can hear her. Like, it's there. I know it's there. They just got to boost it.
Oh, okay.
So I just kept it on all the time. I just explained to them that's why I did that. It sounded very echoey with what the judge were talking. It's not trying to get clean.
Yeah.
And then when he spoke, obviously, they had the mic up in front of him.
Yeah,
so.
yeah.
Wow, what a bombshell, huh?
Holy shit. Yeah. He gave him 32 years and he gets to walk.
Well, he was parole. He goes to parole. He gets to walk. But he gets his right to go to parole hearing, so.
Yeah.
Isn't that right? Because I mean,
yeah,
I don't think he gets to
like, that's what we were all
walk.
back here going, whoa.
I think he gets to go to a parole board.
Yeah.
Wow.
After killing all those people.
Wow, wow, wow.
And all that BS that he was battling.
Oh my God. I zoned out after about the third sentence.
Like,
I got him walking out too.
Yeah. So Fish was like, go get her. And I was like, you go
everything down here?
If you're ready to go, yeah. Do you need anything, Mark? When you guys ready?
Sandwich to the next door?
Pardon?
Sandwich to the next door?
No, good idea, though.
There's hot dogs if they head downstairs. Wasn't it? Whatever it was, I went down there and I was like, oh
One of the lawyers was reporting had a flat tire on the way down. So you know something like that's going to happen. Inevitable.
Well, the good news, she had triple A. Who was it?
Audio, is it okay? Okay.
Yeah.
yes, I do. I work with him all the time. Yeah, Bert. Yes, I do. I know him well. He's on the side of rat cast like words. I was smart enough to be a business guy.
Okay, go ahead and have seats. Right, 2018 CR 157, State of Iowa versus George Wagner III. Set for motion hearing today. Mr. Collins, Mr. Hayes, Ms. Anstead, Ms. Stevens are here for the defense. Mr. O'Brien, Ms. Canepa here for the state. I think there's two matters for the record versus the defendant's motion from last December, renewing a motion regarding other acts testimony. So it'd be like the scope of disability. And then the court's willingness to hear re-argument with regard to the death penalty specifications. So we'll try to knock those two things out of the ballpark here. I don't know, Mr. Collins, Mr. Hayes, you want to talk about your motion? I think it's pretty much oral argument, but maybe it's hearing with evidence.
Thank you very much. I please the court on behalf of our client, Your Honor. We received the government's response to 12:36 last night. I didn't look at it until this morning about 8:30. So with the court's indulgence, we kind of split this up. We're going to let Ms. Stevens make the argument, the oral argument. But I guess would you? I'm sorry.
I didn't see any of it yet, so you're still ahead of me.
Okay.
Go ahead.
Would you like a copy?
They're probably just going to get in the way, so we're good. It might have been filed, I just don't get things because I don't have a
I thought
staff.
I emailed it to you at the same time.
If you didn't
I emailed
email
to
me
them.
at 12:36 last night, it's in my inbox. I left to get here at 6 this morning, no problems, I just don't live on the web. Yeah, like I'm good with all the claims, I'm not finding fault with anybody. I'm just saying you're ahead of me. I read the motions, I looked at the transcripts from the past.
Okay.
I'm already trying to formulate a plan of attack.
May I approach?
Yeah, please do.
There's no writing on there.
Appreciate it, thanks.
So I guess with the court's help, Your Honor, we didn't know, Ms. Canepa, the government broke it up into chunks. and argued 7 or 8 other acts.
It has handwriting on it. So
Oh, I'm sorry.
to do that.
Sorry about that.
Thank you.
You would be able to read mine. The government, Your Honor, took each concept in different chunks, and there's maybe 7 to 10 other acts in each of the chunks. So we either argue in chunks, Your Honor, or in big areas, or if you'd like us to go through every single other act, we're prepared to do that as well. That they listed from the February of 2021. So Ms. Stevens can address that, or we can talk about each one, whatever the court would entertain.
I should just start locally, chunks, if you will.
Thank you very much, Your Honor. May I proceed?
You sure can.
May it please the court. Firstly, Your Honor, the state of Ohio's response relies on the Supreme Court case decided in 2020, State v. Hartman. And we would submit, Your Honor, that the Hartman case is absolutely instructional for this case because it held that that other act evidence was inadmissible. Evidence of the same character that we submit that the state is seeking to introduce with this other act evidence. In addressing, Your Honor, the state's first chunk of an argument, it uses identity. And it uses identity as an umbrella argument, stating that identity is an issue in this case. However, Your Honor, we would submit that just because identity is an issue in this case, it's not a license for a prosecutor to introduce any type of allegation going back in perpetuity against a defendant. And that's what we have here. The state of Ohio has evidence in the record contrary to modus operandi or the identity of the other act evidence in which it seeks to introduce. In the Hartman case, Your Honor, the Supreme Court held that similar act evidence is only relevant. Thank you, Your Honor. I apologize. In the Hartman case, the Supreme Court held that similar act evidence is relevant only if the jury can reasonably conclude that the act occurred and the defendant was the actor. In almost every other act that was listed in 2021, our client, Your Honor, Billy Wagner, was not the actor of the other act evidence that the state of Ohio seeks to introduce. And the state has evidence, Your Honor, evidence in the record that Billy was not there. Billy was not present for this conversation. Billy did not threaten. That Billy lived with his mother at the time that the state is seeking to introduce these other acts. Identity, Your Honor, as the court is aware, is a permissible purpose under 404B when there is a modus operandi, when there's evidence, indicia of modus operandi. We would submit, Your Honor, that none of the information, none of the other act evidence that the state has provided conforms with, shows that there's a modus operandi here. As the court's aware, modus operandi means literally a method of working. Evidence, Your Honor, that the defendant has committed uncharged crimes with the same peculiar modus tends to identify the defendant as a perpetrator of a crime, a fingerprint, or a signature, if you will. The court may have heard it as a strikingly similar doctrine. An example of such, Your Honor, of a modus operandi type for which another act can be admitted into a trial would be something like a fingerprint or a signature. A serial killer shaving the head of his or her victims after every killing. Taking trophies from every type of murder. That is the modus operandi, that is the exception that the Supreme Court of Ohio contemplates. But the state argues that identity here is absolutely an issue and that therefore modus operandi is an issue. We would submit, Your Honor, that modus operandi is not an issue. The utility of modus operandi, Your Honor, comes from its connection with the current crime through shared characteristics that make the conduct unique to the perpetrator. Here, Your Honor, the accused perpetrator is Billy Wagner. There is no fingerprint like of someone who is not our client hacking a Facebook. And these are just examples, Your Honor, of the other act evidence that the state is trying to introduce for Mr. Wagner's trial. There's nothing modus operandi about any of the evidence that the state seeks to admit. As far as common scheme evidence, Your Honor, the Hartman case is also instructive on how this court should rule. Other acts that are admissible for a plan or common scheme must be so inextricably linked, and the other acts must be of the nature that they are carried out in furtherance of the same overall plan. Evidence of a common plan design refers to a larger criminal scheme, of which the crime charged is only a portion. That's what the Hartman case held. The Bill of Particulars, Your Honor, informs we as the defense that the charges we have to defend against, specifically the engaging in corrupt activity charge, stems from January 1st of 2016 until November of 2018. The engaging in a pattern, that conduct that is specifically mentioned in the Bill of Particulars, does not encompass date ranges for things such as citing gas, for things such as Jake's controlling nature of Hannah. It starts on January 1st of 2016. For the court's reference, not when Sophia was in the womb, but rather Sophia was 2 years old in 2016. And so as such, there is no evidence of any type of common plan or scheme that the state seeks to introduce with this other act evidence. Your Honor, we would submit that as far as the state goes with Tabitha and Elizabeth Wagner, we would submit that those same arguments stand with respect to modus operandi. With respect to the various other acts that the state argues concerning the Wagners, the state tries to argue the definition of relevancy for proving criminal enterprise or conspiracy in its response. Yet, Your Honor, criminal enterprise, consciousness of guilt are no exceptions to 404B. The court has a blueprint for how to analyze each and every one of these other acts. First is it relevant? Second is, does it tend to show propensity? Third is there an exception, a non-propensity exception purpose? And fourth, Your Honor, it's subject to a 403 analysis, whether or not the probative value outweighs the prejudicial effects that hearing these other acts could potentially have on a jury. We would submit, Your Honor, that every single act that the state of Ohio listed in its 2021 notice of intent to produce these other acts they're not relevant, they don't meet an exception, and furthermore, when the court performs a balancing test under 403, they're more prejudicial than probative. Now, when you compare those listed enumerated acts that the state provided us in 2021 to its motion response that it provided to us late last night, there are several ones of those left out. And so if the court would like me to go one by one with respect to the ones that are left out and hear argument on those, I can certainly do that, whichever the court prefers. That's all I have for right now, Your Honor. May I have a moment?
In addition, Your Honor, if I may, it's a situation where the rubric established by the Hartman Court, Your Honor, requires that other act evidence be so related to the crime charged in this circumstance that the evidence of the other acts is significantly useful in showing the defendant's intent with the crime charged. And that's on page 58 of the Hartman case. The reason being, Your Honor, the temporal connection requirement is that the probative value of the other act evidence decreases the more it establishes that between the time of the alleged bad act and the time of the alleged circumstances here. And that's an apostasy case. And the government's requirement acts, Your Honor, don't have the tendency to prove the crime, or more or less the ones they're putting forth. And I just have a couple for the court. So the timing, as Ms. Stevens indicated in the government's motions, from January 1st of 2016 through November 12th of 2018. They say that my client threatened someone or threatened to kill them. And it's number 4 under the motion on page, there's not page numbers, on the last page indicating general things by my client and his family. Allegations that the defendant attempted to threaten to kill someone before. So the evidence that in the record, Your Honor, in the first trial was such that Jake said when he was a kid getting stitches, that his father said, quote unquote, to the person giving stitches, boy, if you break that stitch again, I'll break your neck. Okay, that's the type of stuff that they got in that doesn't meet any of the requirements of, under Hartman or anything of that nature, especially the time constraint. There's also stuff about mortgage fraud. There's stuff, each of one you can go to. I'll direct the court's attention to page 2 of some of the acts that Ms. Knepp and the government talks about, and that's with regards to Tabitha Clayton. In Tabitha Clayton, there's 7 listed other acts concepts. But when you take each one apart, Your Honor, and you go to each one in the record, every single time there's a quote, either by Tabitha, either by Jake or Angela, indicating Billy was not involved with that. Billy didn't live there at the time. For the court's awareness, Tabitha lived at the time with George, with Jake, with Angela, and Angela's deceased father's residence. Billy did not live there at the time. Every one of the people, there's a quote, Your Honor. Volume 32, page 7529. Volume 35, page 8313. Volume 16, page 3664. Volume 17, page 3871. Volume 35, depending on the witness, page 8317. All of those, Your Honor, volume 46, page 11089, all of them specifically say about this concept, he didn't live there. He wasn't involved. He didn't have conversations with him. So to impute this to Billy, Your Honor, these are the types of things that when you get to the specifics, it just doesn't make a lot of sense and it doesn't comply with the analysis that the court has to go through, Your
Honor.
All I would say is just plain and simple, they put the cards on the table. The state is trying to get this information in to show propensity, to show bad character. That's the sole purpose. There's not a nexus. There's not a connection to the crime in and of itself. That was the basis, although even reading through the first transcript, there was a lot of other evidence that wasn't objected to. But it is a basis of that deal in the first trial as well, in the assignment of error, that other evidence wasn't out in. We don't see the connection. The majority of this is all tenuous. It does not connect to the inclination to prove identity or motives that Billy Wagner committed to murder to himself.
Did these issues go up to the Court of Appeals out of George's court?
Correct.
Was there a decision?
I don't believe there was a decision. I can't speak definitively.
Still pending. Thanks. One of us need to look for it. Your turn, Mr. Knapp. Go ahead.
Thank you, Your Honor. I guess, the state found its notice of intent to use other acts of evidence back in 2021. I recognize that what they have done, I think, is to go through the transcript and things that came in George's trial that they think should not come in Billy's trial. And the state will readily concede that we agree that some of that will not. We're not at the point where we're seeking to introduce those sorts of things. Lost my train of thought, sorry. But when we're saying things like Billy didn't live there at the time, when Tabitha was there, that's not true. There was a time where Billy was living at the Flying W to help take care of his ailing father, but he would still come over to the house every day, and there was testimony that he did arrive at the end of one of the events there. I guess my general position is it's premature for the court to make rulings on these individual issues. I believe the court has said at least a few times that you've been spending some time with the transcript. But until it's offered, some of this stuff I think came in through George Wagner's testimony, which certainly will not be coming in Billy's. George talked about a lot of other act stuff. But there are things that are, as this court knows, they're charged with a RICO case, which requires the state to establish a criminal enterprise. And, there are going to be things that are relevant to that. The same thing with the conspiracy, Your Honor. In the motion in mind that you do not have, so in other words, because conspiracy requires meeting co-conspirator minds on a common criminal objective, other act evidence indicating a co-conspirator state of mind may well be relevant to explain how a criminal enterprise developed, to help the jury understand the basis for the co-conspirator's relationship of mutual trust, or to complete the story of the charged conspiracy. Both Jake and Angela testified in George's case that it was the tumultuous relationship between Hannah and Jake and their obsession with Hannah and Jake's child were the primary motive in the aggravated murder. So again, some of this stuff too, that in the notice of intent to use other acts evidence really doesn't even other acts evidence. I just threw it in there out of an abundance of caution. The fact that controlling of the females that come into their life, in the state's opinion, is a behavioral fingerprint. They have a definite playbook when it comes to dealing with the females, Hannah, May, Tabitha, Plater, and Beth Ann Wagner. And that playbook gets repeated over and ultimately culminated in the death of 8 people. Because it was when Hannah May said, I will not sign custody papers ever, they'll have to kill me first, that the wheels got set in motion. That was December of 2015. And by April of 2016, Hannah May and 7 members of her family were dead. As a result of that resistance to control that the Wagner family exerts. So, I guess, the modus operandi, with some of the arsons and stuff like that, I know the state argued this in Georgia's trial. It's the same thing. They plot, they have a plan, everybody has their role in the process. After the crime has been committed, they work to cover it up and come up with a story, to put out to the masses or to law enforcement should they come around. So, that is exactly what we see going on here. And again, that kind of goes back to that criminal enterprise. They're constantly committing crimes for financial gain or other purposes, in this case, to establish control of this child that was no longer in their 100% control. So again, Your Honor, I think it's hard because at this point we've not sought to introduce anything. I don't think that everything that came into, in the Georgia's case, the poaching deer or actually the one thing that Mr. Collins just mentioned, he pointed a gun at somebody. We never put that in Georgia's trial. In fact, I would say that number 3, instance of defendant threatening Angela Wagner with a gun. Number 4, this is under, there's been 10 issues under evidence with kind of the general catch-all thing that I have at the end of that. Allegations that the defendant has plotted, threatened to kill others before. We did not bring that into evidence. I would not seek to introduce that. Defendant's involvement in transporting drugs and engaging in drug trafficking. We know that the story of the night, at least according to Jake's testimony, was that they were meeting Chris to do a drug deal or to firm up plans for a drug deal. We think that was a fictitious drug deal, but that Chris Rhoden believed was a real. So there are some of those fringes. But again, at this point, we are not, seeking to admit all of these things that are listed here. But the ones that we would be seeking to dismiss, Your Honor, again, specifically relating around, and I would also say that it's certainly relevant. Because again, that was their motive. It also goes to their motive, which is another permissible use of other acts evidence. And they freely admit that was. It's proof of motive. Opportunity, intent, preparation plan. That the controlling of Hannah May was their motive when they found out that she was going to resist that. So, some of this stuff is extremely relevant and goes to making it more probable than not. And I would also say it is not so inflammatory or prejudicial. It's not like I'm saying, oh, he killed somebody else, or he did this, or he did something really horrible. But they would be like, oh, well, he did that, but he did this, which is the concern with impermissible or acts evidence. That's the propensity stuff. Not in this case, in this case. First of all, some of it is just to tell the story, and I have that quote, and I don't know what it is. But, to complete the story of the charged conspiracy, but it tells you, evidence shows that the tumultuous and strained relationship with Hannah, and more specifically the Wagner's motive in committing the aggravated murders, the murders were the final culmination of their jealousy, possessiveness, and control. And that is it can be relevant just to give background relationship on prepared information on the relationship and as it developed. So again, some of this I don't even think is other acts evidence. Some of the more specifics, when he's saying, well, Billy wasn't there or this or that, I would agree in some of those instances that would not be permissible. But again, there are times where, I mean, they all conspired to commit these murders. They all were doing separate acts. They weren't always together when they were, you know, buying the murder truck or building the silencer or, you know, making purchases. So from those aspects, I think those pieces of evidence would come.
Mr. Bryan?
Mr. Honor, if I might go ahead, say your name, since I came all the way down here to Pike County today and sat in the corner this morning. I'd just like to say, I think the one word, and I'm not sure we used it, premature, I think, is a guidepost here. Some of the things, obviously, that are identified by Mr. Collins' motion, certainly, if they were used in George's trial, won't be used in Billy's, by my view of it. I had not been through this transcript, and some of the other things that Mr. Collins identified that he wasn't there. So what? I mean, I could hire him to commit a murder and be in New York City, and the murder happened here, and the fact that I wasn't there when it was committed is irrelevant. And certainly, if I'd done that 6 times before because I'm a monster trying to kill people off in a drug conspiracy, me being there or not being there or living there or not living there is totally irrelevant. So whether or not other acts is admissible. So at least I think I understand what Mr. Collins' concern is, and understand that the court doesn't want the state to go astray from what the counts are in the indictment with other evidence of acts that the Facebook, for example, surveillance that might constitute telecommunications fraud is a county indictment. That's not another act. So that clearly would be admissible. The forging of documents on birth certificates is a county indictment. That's not another act. So I think they have mixed together certain things, claiming them to be other acts when they aren't other criminal acts by the defendant that are under 404B, but rather they're state's evidence to prove a count in the indictment. So that again goes back to where I started, that I think if the court's going to review this and write a decision with certain broad guidelines, that might be the proper, but otherwise I think that it really is premature. And I think at the last hearing, Mr. Collins even said that if this was something that might be able to be considered through the flow of the trial as the issues arise. So unless the court has any questions, I would have nothing to do about that.
Thank you, Mr. O'Brien. So I articulated my reasons for saying that the death penalty specification should be dismissed. Number one on the list was listing of lawyers seemed to make that an easy no-brainer, and then I found out that listing of lawyers isn't always advisable. Or when we do so at our own risk. So that was the beginning of a cascade downward into the Court of Appeals, which is fine. I appreciate the fact that they can help guide trials along the way. But Ms. Knapp, I thought that that was like without enough notice. So if you want to have a record, you're welcome to caution me about not believing what lawyers tell me. So you want to straighten me up. I set the death penalty aside because I heard for months, Mr. O'Brien, that the lawyers, you were here, would actually, 100%, yeah, I appreciated the fact that you were willing to encourage me to delay and give you some more time, and maybe that's still appropriate, but I did grab a hold of the fact that you thought you didn't have adequate time to argue, so I gave like the obligatory 10 points, literally 11 points, about why that seemed to be necessary and appropriate. And if she didn't get enough chance to answer all those points, I'm going to revisit that just so like I can make sure she can advocate. So just picked up and said, we're all here, and the court reporter's got fresh fingers. She can write down whatever Ms. Knapp would like to do to set me straight. I only acted in like reliance on lawyers. not hoping to embroil the Court of Appeals in what I already called invited error, but that's at a different level. So scold me for listening to you, actually.
Well, at least, Judge, I think my view is that since the notice of appeal was filed, that the state would not be able to add or supplement the record, the court would not be able to do so either.
But my notice went on before yours that I was going to reconsider, so you don't maybe have a final order. I can still hear this, I don't have to act on it, but in fairness to you, I'm not going to interfere with the Court of Appeals. I said to you all I wouldn't interfere with the appeal, but I would keep this trial moving. I didn't cancel any dates. We got a lot of work to do, so while the Court of Appeals is doing its job, I can still have the second track, but if I went afoul, then we still have time to fix me. So, fix me, would you please?
Well, at least, Judge, I think that it's proper for the court to hear this motion under 404B to in limine today, because that doesn't involve the issue that's in front of the Court of Appeals, but at least my view is since the issue on whether the death spec should have been dismissed under those circumstances at the time is in front of the Court of Appeals, that we would not have jurisdiction or ability to supplement the record, argue the record, for the court make other findings or defense present something further. So at least with that view, I don't think the state would have any further to present.
So like my understanding is I can't act in contravention of the notice of appeal. But hearing argument, taken under advisement, is not an act. This is how I see the law. Like I wanted you to have the opportunity to make your record so we don't have to schedule another hearing and waste more time, have further delay. So I won't act on this. I will just hear this, take it under advisement, let the Court of Appeals give me further guidance. Like I expect lawyers to be doing 5 different tracks of work simultaneously, not one thing at a time, followed by one thing at another time. Otherwise, we don't get anywhere. So like I run 4 different railroads going the same direction. And that's what I think we have to do, is run multiple actions simultaneously. So I would invite you to like help me understand better how it is I went afoul so I can fix it faster to keep the railroads running. And if you don't want to argue...
Yeah, well, Judge, I think the only thing you could do is set aside your dismissal of the death specs, and that would interfere with the jurisdiction of the Court of Appeals.
If I did that in advance of their decision, maybe, because it's not contrary. In essence, I'm giving you trial level. I wouldn't do that. I told them I'm not going to do that. But like you don't want to argue now what you wanted to argue before. I'm not going to make you argue, but I might not give you another bite at the apple later. I might call this a waiver if you don't want to give me the argument today. I'm not saying what I'm going to do. I'm just saying there's 4 railroads running the same direction simultaneously. That's how I work. So I would be curious in having this railroad loaded up and ready to go while I'm working on the other railroad, other acts testimony, while I'm already working on jury instructions, while I'm already getting ready for a different venue. There's more than 4 railroads running one direction in my mind, and if everybody's used to doing one at a time, shame on you, because we can't. Nothing personal, but I run into a lot of lawyers who can do one thing at a time before they do the next one thing at a time, and that's why they're slow, and that's why I can't do that, because like I'm here to get this case done properly, timely. So I want to run like multiple railroads.
Well, I think that's proper, Your Honor. I guess the railroad dealing with whether death specs are in the indictment or dismissed is out of your hands, in my view. That railroad is in the 4th district. Is this the 4th district?
Okay, so you don't want to argue further. Okay, good. I'm not saying I won't give you another hearing. I'm trying to be efficient.
Okay, well, I understand and appreciate that.
Yeah, no, 100%. I'm trying to be efficient. Like I got everybody here on a date that was scheduled last June. We're right where we're supposed to be through today. Let's use the time. But I get what you're saying, so you can be comfortable, sit down.
Okay, thank you, Your Honor.
Your respect was appropriate, as I would understand, Mr. Bryant. Thank you for that. You don't have to. I'm going to go to Mr. Collins or whoever wants to speak to it from your side. I don't think it's fair. I'm just trying to give you a chance to make a record.
Please, of course, John, I don't believe you ran afoul. At the prior time, we had filed a motion to dismiss the death penalty statute based on the agreement that was made by the government and Jay Wagner. The representations that were made were consistent since you've been involved in the case. There were some misrepresentations made by the government in their motions to file. Specifically, our client knows the government's listening to every one of those phone calls, so he likes to mess with them, so to speak, and things of that nature. So, but we were in good faith. We've always been in good faith, and our client in our communications that I can't go into was acting in good faith as well with us, and we were all on the same page. So, I've had communications since that indicated they would give me a thing, give me another, give me the agreement, give me anything. I've never had anything. It's just been shut down since that day of hearing. So we believe that. We don't have a lot to argue, Mr. Davis.
The only issue that I have is when the state was started, after they reportedly listened to some of the Billy Wagner's phone calls, which we never received, there was an insinuation that we were always acting in bad faith. And that's absolutely false, and we take issue with that. Without getting into the communications with Mr. Wagner, we acted in good faith. We were proceeding in good faith. We had an intention to go forward with a trial in the state with the death penalty specifications off the table. It, in essence, deprives us, we believe, of due process to try this as a capital case. Halfway through the trial, then remove the death tax. So we were in agreement to do that. There was communications with the state. They were going to get us back another record. We never received that, and we were here before. But it was another agreement. It was our intention to have that completed before that court date. So at no point in time was there any bad faith under the fence, and that's what I take issue.
Thank you very much.
Your Honor, if I may,
yeah, go ahead.
Certainly, this case, which started as a court notice on November 20th, at least was saying on jail phone calls that he was not going to enter into any such agreement.
Thank you for that professional statement. So I'll acknowledge that the other act's decision is likely to be couched in terms of an in limine, as it should be, advisory opinion. For everybody in the back of the room that don't speak lawyer speak, we're trying to decide in advance what's relevant evidence. But the reality of it is you don't make that decision until you get to the courtroom and have the full context. So when they that's what we're trying to sort out. It has a lot to do with the nature of the charges. It has a lot to do with the scope of the indictment, but it's going to be advisory. It does help because, frankly, we've got to make sure we're efficient when we try the case. There's no sense bringing in a witness from someplace that's going to take the stand and find out in 30 seconds everything they want to say is not coming in. So I'm pretty much a harper on make the railroad understand the scope of the trial. Go ahead.
Please, the court, with regards to, would you want a written response to the government's motion from us? Would that help, or is 10 days okay for time to respond?
Are you going to do the work for somebody else?
Ms. Stevens is going to do it.
It's 10 days.
Thank you, Your Honor.
All right, see what you ask me. The decision, looking at the indictment, and I get a different motion later on under Rule 15 and 17, wherever they are, then the whole apple cart goes up in the air. I don't know the answer, just saying anything I give you is always going to be subject to wherever we are at the moment. Good luck to me. When we get a decision from the Court of Appeals, whatever it might be, I don't expect to give you the luxury of a lot of time. With all due respect to any other judge who's committed to anything other than short term, whatever short means.
Would the court have any indication of what short means? Only for, I can't speak for Mr. Hayes, and Chance said, or Mr. O'Brien, Mr. Neville, but I know I have I know the month of March, and the end of February, month of March is a police shooting. Entire month of May is a police shooting. Entire month of July is a police shooting. I'd be happy to go in between, but any help the court may give, those individuals.
Anything I do is going to make everybody else's life uncomfortable. Thank you for the offer. If we're not going to get both ways, 100%. I'm going to call any judge that scream at you and use my best manners to explain my problem. But that's I don't know the answer to that. I mean, it's not, I don't have that consideration. I have jury commissioners. I have deniers. Like, I'm way out ahead of you because you don't have to be out there. But I do. Thank you for submitting your proposed jury questionnaire. Twice edited. Oh, you don't know that. I'm probably not going to give you a chance to argue it either. I'm just going to do what I got to do to get there. Thank you for helping me. Seriously, we're making progress. Everything that happens in the room isn't everything that happens. Has to get done outside the courtroom also. So you're probably running more than one room tonight. I'm totally running. And I don't have one case. You don't have one case. We all have to run. Does anybody need the record for anything else? Ms. Canepa?
Yes, Your Honor. I don't know if the court, given none of us knows how the Court of Appeals is going to rule, or if somebody's going to appeal that decision. I know the courts, defense attorneys are allowed to talk to the court ex parte about fees for experts or whatever. I don't know how much they got done. I mean, this case was indicted in 2018. I don't know how much they got done.
Percent for you to decide because you're the one telling me we're not going to need mitigation. So either you intend to keep the death penalty all the way through, or you intend to remove the death penalty mid-trial. And now if you're saying it's definitely not negotiable, I want to know if it's not negotiable.
Oh, no, I'm not saying says that I will dismiss the suspects if he testifies. If he doesn't, then I would not. So that's not that's always been the case. That's never been different.
Talk to all those people out there that don't read social media, but like every time I get more information about the done deal dismissal withdrawal, it helps me understand the validity of the statements that we're not going to be doing this. Like every time you come in and tell me more about ethical problems, ineffective assistant counsel, and now here's the terms of the agreement, I better understand how you were all too optimistic in your assurances that we weren't going to be there. So I'm not going to, I get your problem. I'm not going to have that answer. I would consider that a strategy. So thanks, you have a different time.
Yes.
Go.
I would like to amend the bill of particulars. The count 6, 7, 8, and 13 should say Scioto County. It's in the transcript that they were provided, and they provided the transcript 2023 sometime. But when, the court asked for the bill of particulars, and I was looking through it myself for the other act stuff, it's possible I've done that already, but I don't know that I have done that. So I would move to amend the bill of particulars.
How do you want to handle that? This is year 9, right?
Sorry?
This is year 9. We're coming up on the 9th anniversary, right?
Charged 18.
Yeah, the facts happened at 16. Okay. I'm just like being a little bit snarky at the moment because I can see it from your face, so why don't you just have at it? The indictment's in 2018. I understand the bill.
What I was going to say is that the lead-in language to the indictment says that within the body of Pike County, where some men are enumerated in 2901-12 of the Ohio Revised Code, where the proper venue is placed in the county of Pike on their oaths in the name and by the authority suit. So,
How do you want to handle the request for amendment? You want it in writing, and then you get a response in writing?
Yes, sir.
Yeah, like, I get where we are. Didn't see that one coming. But that's why I asked for the bill of particulars. Like, I'm to the point now where I can drill deeper into all the stuff that you're years ahead of me on, if in fact you're ahead. So she's going to file a written motion to amend the bill of particulars, and you want how much time? Okay. And then how much time behind it did you want for your very capable staff?
7 to 10 days.
Okay, we'll have a good, solid record of what we're asking for. Anything else you want? Mr. Bryan looks like he's got one.
No, I was asking Ms. Knapp similarly to the court later. There was anything. So I have nothing further. Thank you.
All right, anything else?
Oh, thank you very much.
All right, thanks again to the court staff. Go ahead and stand adjournment. Oh, no, we won't. Let's talk about our next scheduling. Phone call, do that. I'm going to do it right now. Draw off the record. Let's get our calendars and phones and things like that. It doesn't seem to be a good way to
still has that case, so we have 3 weeks. Now we're back to read.
You're the one with the busy schedule.
The judge, that's not every other week, maybe a few, but it's
When war happens, it's going to be like 0 to 150. Right? So like before you can be ready for the acceleration.
Right.
Like I'm now going to think comes to see you. Think of yourself as a target. Remind me. Then I was thinking we could call the schedule because we all got our phone calendars.
That Friday morning.
I can do that.
And
No, she's.
we'll get along just fine.
Okay. Well, I'm sorry, what day did you say
I think they can't do that, right?
She said it's just
I'll see if I can get Kathy.
we're going to do other stuff. We're going to do other stuff. Did you read my statement? Decision. The first half said I would respect to stay on the issue of appeal. I should. The second was I would not stay all around. I didn't pick the kind of
That's the one they used to check.
I keep finding out from you guys what else is out there every time I go.
I'm like, what are you laying on the floor to take that picture?
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.